Judge Shapiro, we do have the parties, but I'm not seeing that the court reporter has signed on yet. I'm going to reach out to the recording service to see how much longer they'll be.
Okay, that's fine. Thank you.
Judge Shapiro, we now have the court reporter as well as the parties, so I can bring them in whenever you are ready.
I'm ready.
Good morning, Your Honor.
Good morning. Is it Waddell or Wad? How do you say your name now?
It's Waddell.
Waddell?
Yep.
Thank you. And you represent the state?
I do, Your Honor.
Okay. And is it Mr. Rubenstein?
Yes,
Rubenstein?
Rubenstein. Rubenstein is fine. Thank you.
Okay. So, this is the state's motion. Am I correct?
Yes, Your Honor.
Anything preliminarily before we just proceed with the argument?
Not on behalf of the state, Your Honor.
Nothing for
Did
plaintiff,
you
Your Honor.
Case yet? Did you call the case yet?
No, thank you. I'm about to call.
Okay.
Thank you. All right, this is the matter of Mylon Harris versus Michigan State Police, Court of Claims number 21-183 MZ, and we are here on the Michigan State Police motion for summary disposition. So, Ms. Waddell, go ahead and place your appearance on the record, and you can begin.
Thank you, Your Honor. Mary Waddell, Assistant Attorney General, appearing on behalf of the Michigan State Police, the defendant in this matter. Your Honor, I assume the court has read our briefing. This case just simply involves a seizure of funds and 2 cell phones done by a couple of troopers. Mr. Harris has sued the state police, not the troopers, seeking damages and or injunctive relief to obtain the money that was seized. As I stated in my, I'm sorry?
As well as his car, I presume.
We don't know. He has his car.
He has the car. Okay.
Yes, he has the car. We seized cash and 2 cell phones, and they're being retained as the investigation's ongoing. Your Honor, as I stated in my brief, we believe he's failed to state a claim. There's issues of governmental immunity, sovereign immunity. Essentially, to be perfectly candid, Your Honor, he's got the wrong defendant in the wrong court.
Well, let me ask you a basic question. I'm new to, this is an area of law I haven't dealt with. I'm new to the Court of Claims. On what basis are these goods being held? I mean, I read the statutes. I couldn't figure out on what statutory basis you're holding them.
Well, Your Honor, they were seized pursuant to the automobile exception to the 4th Amendment. So the officers determined that they had probable cause. They've seized it and they're holding it as evidence.
Right. And what is the case law or statute that allows you to hold something as evidence for 8 months without the charge?
Your Honor, I believe in my brief, I cited, I apologize. There's a case, Your Honor, that I cited in my brief that basically says, Robinson v. Inches, Your Honor, that's 220 Mich 490. It basically says there's no duty to return property seized as potential evidence if the criminal complaint is still being contemplated. And our trooper submitted an affidavit stating that the criminal case is still being contemplated.
And do we know what the probable cause is?
Yes. I hesitate, Your Honor, because the investigation is still ongoing. But basically, Mr. Harris allowed the officers to view his phone, and based on images that were on his phone, the officers determined that they had probable cause to seize the cash and the phones.
Why do you need the cash?
It's evidence of a crime, Your Honor.
Okay, and so your position is you can hold this indefinitely until such time as the investigation closes or a trial and appeal is complete.
Well, yeah, well, as long as a criminal complaint is still being contemplated, we can hold it as evidence. If Mr. Harris wants to challenge the seizure, he does have recourse, but it's not in this court against this defendant.
Well, what is it? What is his recourse under?
He could bring a claim and delivery action in circuit court, Your Honor, or he could file an action under, one second. where's the statute? MCL 600.2920 sub 1. But again, it's not against the state police.
Just say it again. 600 point.
600.2920 sub 1.
Okay, hold on 1 minute. I haven't looked at it, so I just want to see what it says. 600.2920. Sorry. Actions to recover possession. So is it your position that an action under this provision would have to be brought in the circuit court, even if this defendant is a state entity?
Well, the defendant can't be the state entity, Your Honor. That's the point. So if he sues the correct, I'm sorry?
You're saying the state police cannot be sued for a return? I'm just, like I said, you got to explain a little more to me.
No, Your Honor. Basically, these are tort actions. It's replevin and conversion. So under the GTLA, MSP is immune unless it falls within a statutory exception. Again, if
But we
he's
do know, counsel, I'm going to stop you for a second. I'm sorry I keep interrupting. But we know from Genesee County, Genesee Drain Commissioner, that, let's see, maybe this wasn't circuit court, I don't know, that restitution and unjust enrichment is an action that can be still brought against the state, right? Or maybe you haven't read that one, but that's my reading of it.
I believe that's a fairly recent case, is it not, Your Honor? Yes. But Your Honor, he didn't bring a claim for unjust enrichment in this case. He's seeking claim and delivery and or conversion, which are both intentional torts.
And you're not asserting that he's failed to do something proper under the forfeiture statutes because you haven't asserted a forfeiture. Am I right?
Correct. Absolutely correct, Your Honor. We're not seeking forfeiture at this time. Obviously, if criminal charges are brought, the prosecutor may seek forfeiture under the Omnibus Act at some point, but that's not the case here. This property was seized as evidence of a crime.
Okay. And is the most recent case you have 220 Mish?
I think there was one other. I apologize, Your Honor. I think there was, I want to say it's Lewis versus the city of Detroit. But I'm not seeing the site right here.
I don't have the site, but do you have it? If not, it's okay. But if you've got it, give it to me.
I can find it in just a second, Your Honor.
All right, well, why don't you find it while your opposition is arguing, while you're talking, okay?
Certainly, Your
But
Honor.
I've done a lot of the talking, so if you want to cover more, feel free, and I'll be quiet now.
No, Your Honor, we would rely on our briefs. I think this is a pretty straightforward issue. At least I hope it is.
Okay. All right, Mr. Rubenstein.
Thank you, Your Honor. Jan Rubenstein, on behalf of plaintiff in this matter. A couple of things I want to bring to the court's attention. We did initially file this in circuit court. Ms. Waddell filed a summary motion in circuit court, and I quote from that summary motion, "The Court of Claims has exclusive jurisdiction over plaintiff's purported claims. This court may take no action but to dismiss the case." And she went into a lengthy, detailed analysis of how the Court of Claims is the only jurisdiction where this could be brought, and the circuit court would be the absolute improper jurisdiction. Clearly, now we're in the Court of Claims. You know, the goal here, it appears by defendant, is to devoid a citizen of any opportunity for any due process. Now, I would also indicate that the state of Michigan, the state police has the burden of proof as it relates to this summary disposition motion. Simply saying there's an ongoing investigation and an officer had probable cause is not objective probable cause. Okay, that doesn't satisfy any burden whatsoever. And frankly, to be coy about the argument and suggest, well, there's an investigation of something somewhere and something was seen somewhere, but Judge, you have to basically take our word for it. Your Honor, that's not what the law was intended to protect. The Constitution was intended to protect the citizens from exactly this type of overreach. Now, we did not sue the individual officers. In the event that the court finds that to be a defect, I would ask the court to allow us to amend, but I didn't believe, it doesn't appear that.
What court would that be proper in?
Well, I believe it would be proper here because Ms. Waddell successfully argued to the circuit court that the Court of Claims had exclusive jurisdiction. So at some point, she can argue that every court is devoid of jurisdiction and we have to go somewhere else until my client gets frustrated and apparently they hope he just goes away. Okay, which in this case is not going to happen. But the circuit court judge in Paw Paw, Michigan was convinced by Ms. Waddell's very eloquent argument that the Court of Claims had exclusive jurisdiction over these matters. So, Your Honor, I don't see this as a gross negligence case because this was an intentional act. They took his goods. There was nothing inadvertent, accidental, or negligent about it. However, again, if the court thinks that there's technical defects in my pleading, I'm happy to amend the pleading if the court would give us that opportunity. But again, the facts here are very simple and very basic. My client's been charged with no crime. Ms. Waddell has articulated no crime. No potential crime has been brought to either my attention or this court's attention. They simply stopped a minority individual. They took his money. They took his cell phones. They didn't properly record his cell phones. And in doing so, they violated, and the statute we cited in our brief is MCL 333.7522. There was no circumstance under which these goods were properly seized. Counsel goes to great lengths to—
Counsel, can I stop you for a second?
Sure.
What was it you said, that the phones were not properly recorded, did you say?
Yeah, they were not properly reported. There was a seized cash form that was signed by the sergeant and it simply identified the money taken. Nowhere was there an identification of the cell phones.
Okay.
So there's a
It doesn't seem to
procedural
be a
defect.
dispute that there are two cell phones, right?
I don't think it's
Say that
disputed.
again, Judge. Okay, Judge, you're talking over the other, I thought I didn't hear the
Oh, yeah.
beginning.
I forgot there's a court reporter. My apologies.
Yeah,
Go
yeah,
ahead.
please,
Mr. Ruth.
one at a time, please.
Sure. So I don't believe
I
that
didn't hear
that's—
the judge's question, Mr. Rubenstein. He needs to put that on the record because you're answering something that won't be on the record.
Sure. Sorry about that.
Judge, your question to him was? What was your
I don't
question?
I was asking about whether or not, but I said there's no dispute that the two cell phones were seized.
Correct. And I believe that's the case. In our pleadings, in the state of Michigan's pleadings, there's been no suggestion that that's an untrue statement, that these cell phones were not properly seized. They just were not procedurally accounted for in any way on any type of document. So essentially, I mean, and we briefed this issue, I hope fairly well. Essentially, this man was stopped. All of his money and his cell phones were taken, and there's no crime. And Ms. Waddell in the state of Michigan attempts to justify the actions taken and dismiss this case now for a second time by saying, number one, you can't sue here. You have to go back to the court I told earlier that you couldn't sue in. And number two, even if you could sue us, you know, you haven't properly challenged the forfeiture because there is no forfeiture. No proceedings of any kind have been initiated. Your Honor, what the state of Michigan here has done is just insufficient. This court has an obligation, in my opinion, to protect the citizenry from overreaching of the law. And in this particular case, there's been no showing nor even a declaration on the record by Ms. Waddell about what they think they're investigating. We're now from April of 21, $19,000 is gone, 2 cell phones are gone. There's no traffic ticket. There's no parking ticket here, much less a crime. And the fact that we have an affidavit that spells out that there's some inarticulable crime that we believe there's an investigation ongoing is not a, pardon the pun, is not a trump card to just do whatever they want for the rest of eternity. The court's question was very poignant. Where are the limits? Under Ms. Waddell's theory, there is no limitation on the court's ability to act. I'm sorry, the state's ability to act, on the state's ability to seize property, to provide no justification, to provide no due process. And basically we're arguing Ms. Waddell's challenge to my pleading is a technical defect, which can easily be rectified if the court agrees with her on an amendment. But where's the basis to do what's been done here? Where's the basis to keep this all a secret and covert? And what are the limits? If this had been done 5 years ago, would Ms. Waddell be making the same argument? If this had been done, I mean, if this was $100,000, would it make a difference? It doesn't affect my client's property rights, Your Honor, and the state of Michigan has an obligation at this point. By the way, and I'm sorry.
Go ahead. You can continue, sir.
Okay, and I also did cite in my brief that immunity is not granted where a governmental employee acts maliciously or with wanton or reckless disregard of the rights of another. And that's citing to Odom v. Wayne, 482 Mich. 459 at page 474. It's a 2008 case. And that's exactly what we have here. Governmental immunity does not apply, or at a minimum, there's a question of fact as to whether or not governmental immunity applies, because these officers, it appears, acted maliciously and or with a wanton or reckless disregard for the rights of another. And counsel in the state of Michigan hasn't even attempted to suggest otherwise. In fact, what they do an excellent job of briefing the technical issues, but what's severely lacking is any substance. Why were these things taken? What was found? What are they investigating? What's going on here? And at some point, myself as an attorney, this court certainly, and my client as a citizen has a right to know that, because this money is a lot of money for him. It may not be a lot of money in the eyes of some other people, but this is a lot of money for him. He's got property rights, and there's no basis to indefinitely deprive him of those without any legal cause. There should have been a forfeiture proceeding. Go ahead. I'm sorry.
Rubenstein, what is the outer limit of the state's authority to hold evidence pending a charging decision, and where does that authority lie as you understand it?
Well, and it's a great question, because I don't know that I've seen a specific and detailed answer to that. We have to start with the location and the time when the property was seized. And MCL 333.7522 outlines where you can seize property without process. And this doesn't fall into any of those subsections.
Mm-hmm.
I identified the elements on page 4. In the event.
Hold on, just a second. Sure. Hold on 1 second.
Sure.
But your opposing counsel argues these statutes don't apply because that's about forfeiture, and this isn't a forfeiture. We're just holding it pending a charging decision. So all of these requirements under the various forfeiture provisions that I reviewed, their position is none of them apply.
And that's a misreading of the statute. The statute that I just cited, and I'm quoting from the statute, property that is subject to forfeiture may be seized upon process issued by the circuit court having jurisdiction over the property. Seizure without process may be made under any of the following circumstances.
Right.
That doesn't require forfeiture without process. That says seizure without process, which is what's been
What
done
about
in this.
subsection? What about
Sorry, wait,
subsection
Mr.
D?
Rubin, excuse me, I didn't hear what the end was. That says seizure without process, which has what?
I'm sorry, Ms. Roberts, I didn't.
The judge interrupted you, so I didn't hear the end of what you were saying. That doesn't require forfeiture without process. That says seizure without process, which has
Essentially 4 allowable elements. And to your Honor's question, subsection D, there's probable cause to believe that the property was used or is intended to be used in violation of this article or section 1776A. There's been no showing, nor even an allegation by the state of Michigan that there was probable cause. And if there was, they have a duty to substantiate that probable cause. It is the moving party that has the burden of persuasion in a situation like this. They filed the motion. They filed the motion with an affidavit that literally, and I mean literally, says nothing. It just says, and we articulate this, that you have to take our word for it. If we use the word investigation, that's carte blanche to take and do whatever we want to do. That's not the summary disposition law. That's not what the court rules say as it relates to the burden of proof on summary disposition. Ms. Waddell would have been able and certainly capable of providing affidavits, screenshots, testimony, indictments, whatever else she has to suggest a criminal activity was afoot. But as we all know, even going back to a simple traffic stop, you need reasonable, objective, and articulable probable cause. And we have none of those. We just have a claim that there's unidentified probable cause, and that's insufficient.
Okay.
And Your Honor,
So
I'm
let's
sorry,
go back.
just to wrap up, even when we get beyond that, beyond the seizure without process statute, and I'm just going back to your question, then we still have to look as to confirm that the acts were undertaken in good faith. And again, that at a minimum, in this particular situation, is a factual question. Because it appears here that, again, there was no regard for the property rights of my client. There was no good faith, and there's been no attempt to suggest that by showing of any potential crime, potential investigation. It's all just very coy and down low that nothing's being disclosed to this court. If they can't disclose it to this court on the record, or to myself or to my client, this property should be returned. Now, if counsel thinks I brought it under the wrong cause of action, like I said, I'll be happy to amend.
Okay, let's go back to Ms. Waddell. And first off, did you happen to find that site?
I did, Your Honor, and I was incorrect. It's Lewis v. Wayne County Prosecutor's Office. It's actually an unpublished opinion of the Court of Appeals. The docket number is 322935, and it was issued April 26th of 2016.
Of 2000?
2016.
Oh, thank you. All right. Now, give me your side of the story on the dismissal of the circuit court case.
Yes, Your Honor. Plaintiff is misunderstanding. His defendant in this case is only the state agency, and you cannot sue a state agency in circuit court except in very limited circumstances, which this is not. He did not sue any of the troopers in this case. If he had sued troopers, it would have been a different argument, but he's only suing the Michigan State Police, which means this court would have jurisdiction over the Michigan State Police. So
Why would he? I'm sorry, I forgot the court reporter. Go ahead.
So that's the argument there, because he only sued the state police. He hasn't sued any of the troopers.
Okay. Why would there be a claim against the individual officers since they're not in possession of the materials?
Well, if he's seeking injunctive relief, Your Honor, because there's a Fourth Amendment violation, you can't bring a 1983 action against a state agency. You have to bring it against the individual officer. If he's seeking injunctive relief under Ex parte Young, it still has to be brought against a state officer. And that he hasn't done that here. He's suing the state.
Okay.
So that's the issue there. Second, with respect to the forfeiture statute, again, he skipped over the part that says property subject to forfeiture. We are not seeking forfeiture. There's a difference between property possession rights and title. Forfeiture deals with title. We're talking about possession because we're holding it as evidence of a potential crime. So the forfeiture statutes don't apply. So again, we're in the wrong court with the wrong defendant. And the same issue arises when he cites Odom. Odom is a seminal case, absolutely, but again, it only applies to governmental employees. It does not apply to the state as the defendant. So that's the issue here.
All right, so could you please list for me, I'm sure it's in your brief, what are the technical defects? So far, you've told me no suit be individuals, right? And that would be in circuit court.
Right.
You say there's no claim for claim and delivery, right? And you say that has to be in circuit court?
Yeah, against a different defendant, Your Honor.
Against whom?
It would have to be one of the officers. Because if you look at the GTLA, these are intentional torts, Your Honor. So unless an intentional tort exception applies, we have governmental immunity. Now, you can bring an intentional, I'm sorry, Judge. You can bring an intentional tort claim against a state employee. Granted, they have, it's a heavy burden to actually overcome that immunity, but you can actually bring the claim. You can't bring the claim here. There's no intentional tort exception to governmental immunity for the state.
Okay, hold one moment. What about the injunctive relief? That doesn't seem to involve a tort claim.
Well, that would be the tort claim is the underlying cause of action to issue an injunction, Your Honor. An injunction isn't a cause of action. It's a claim for relief. So he would have to
Well,
demonstrate. Go ahead.
If the property rightfully belongs to him and you don't have a right to hold it, you're saying that he can't bring an action for an injunction to have it redelivered to him? He has to sue for an intentional tort?
He can, he would have, you have to, Your Honor, under the two claim and delivery statutes that I cited, he would have to bring a claim seeking injunctive relief against one or more of the officers in the proper jurisdiction, and he would have to establish that the property was being unlawfully detained. But you don't bring it against.
Obviously, he can allege it's unlawfully detained because there's been no explanation, according to him, in his view. Is there anything else? I mean, he doesn't have to come forward and prove that there's no probable cause, right? That's your burden.
Well, if he's going to bring a claim into delivery action, Your Honor, it's his burden to establish that he's entitled to possession of it.
All right. And when do you anticipate that this investigation will be complete?
Oh, that's a great question. I don't know, Your Honor. I checked with my troopers last week. They're still going through everything. And then with the prosecutor's offices, they're really backed up. So honestly, I wish I could tell you, Judge, I don't know.
Okay, I'm trying to look at this Lewis case quickly.
Mm-hmm.
And it looks like there was a search warrant in that case, wasn't there? I think so.
Potentially, I don't recall, Your Honor.
Okay, well, I'll read it, that's fine. All right, anything else you want to say, Ms. Waddell?
No, Your Honor.
Okay, Mr. Rubenstein?
Your Honor, the only thing I want to say is that counsel is overlooking when she claims that we can't have an intentional tort based on governmental immunity. She's overlooking the Odom case that speaks directly to this point. And the Odom case indicated that if plaintiff pleaded an intentional tort, determine whether the defendant established that he's entitled to governmental immunity under the Ross test. And that's where we cited from the Ross case that required good faith. Okay, and I don't want to repeat it again. And that's something that they require in order to obtain governmental immunity. And they simply can't overcome that threshold, especially not with the record that's been created here, which is just devoid of any real facts.
Okay. Anything else from anybody? Very well.
Your Honor,
I will issue an order. Yes, ma'am.
If I may just respond to that briefly. Again, Odom only applies when you're suing a governmental employee, not when you're suing a state agency. So it's inapplicable here.
And you're saying if it's a governmental employee, he has to go back to circuit court.
Correct.
Right. And are you going to claim that there's res judicata when you go back to circuit court?
Well, no, because there hasn't been a decision on the merits, Your Honor.
Okay, good. All right, very good. Anything else?
No, Your Honor. Thank you for your time.
I will issue an order and/or opinion, I hope within the next 14 days, hopefully sooner. Okay?
Thank you, Your Honor.
Thank you.
Thank you both, and thank you, Madam Court Reporter, for your time.
Anybody need any transcripts? Anybody need any transcripts?
No, thank you.
Not at this time.
All right, thank you.